Hi everyone, welcome to this video. I'm Natalia Fritzen, Sumsub's AI compliance specialist, and I'm taking over our Sumsub Expert YouTube channel once again, this time to talk about deepfakes. Deepfakes was a term coined for the first time in 2017 when a moderator in the platform Reddit used the face swap technology to create pornographic content based on celebrities' likeness. Deepfake is a type of synthetically generated content with the purpose to deceive. It does so either by video, audio, images, so on and so forth. It is precisely the maliciousness of deepfakes that makes it different from other types of AI or synthetic generated content, and also what makes it a pertinent topic of discussion today. We are now in 2024. We have the biggest election year in history, with roughly 64 countries heading to the electoral ballots. This year, the public attention has turned to deepfakes once again, a phenomenon that has been creeping around for some time already, but has only become increasingly concerning since 2022, more or less, when ChatGPT was released, and access to sophisticated and very popular AI technologies has increased. Experts calculate that in 2023, roughly 500,000 deepfakes were spread in social media. And we came to a point now in which researchers have recently discovered that about 70% of Americans believe that it is likely that the US elections this year will be affected somehow by deepfakes. So the goal of this video today is to analyze this phenomenon of deepfakes from a legal point of view and ask ourselves questions such as: can current regulatory frameworks offer some type of protection against deepfakes? If not, should we create new legislation? And if we create new legislation, how should these legislations look like? These are all questions that policymakers around the world are asking themselves right now. And the idea in the video then is to analyze what different countries are doing in order to handle deepfake threats. Let's have a look. Before jumping to analyze what these countries are doing in terms of deepfake regulation, I wanted to give just one step back and ask the question of why do we need to regulate deepfakes in the first place? If you're tuned into these debates of deepfakes, you're probably aware of many different technical remedies that have been suggested as a way to protect us from deepfakes. We have deepfake detectors, we have watermarks, and we have technical standards. But most of them, when we put a close eye, we can see they have some shortcomings. And the idea now here is to understand if the shortcomings could somehow be helped or be solved by having regulations. So one of the first technological remedies that have been proposed is the idea of deepfake detectors. Deepfake detectors are, put very simply, technologies that can detect whether a certain content is synthetically generated or not. The problem here is that we, in Sumsub, recently conducted a research in which we discovered that these detectors, the efficacy of them, can be a bit questionable. So, in short, what we discovered is that modern deepfake openly available datasets are built using outdated technology. What does this mean? This means that some open source modern detectors, especially those that are available out there to everyone, they learn to find outdated deepfakes only. The problem is that this creates a mismatch, right? So deepfake generators, they tend to have a better quality than deepfake detectors, which then put us in a type of hide-and-seek dynamic, where fraudsters are always one step ahead of the technology that can detect them. Most importantly, detection technologies, they will often only give you an authenticity percentage. So they will tell you what is the percentage that that content is synthetically generated or not. And this might raise all sorts of additional questions. So for example, what is the threshold for what is considered authentic or not? And who should be the one determining it? Altogether, the shortcomings about the quality of the detectors and the authenticity percentage, they point to the fact that deepfake detectors alone might not be sustainable. They might need some extra help in order to fully develop their potential. So when it comes to regulation, the question that we could raise here is, for example, if regulations could establish quality criteria on how these detectors should be developed in order for them to be truly efficient. Another technological remedy that is worth a look is watermarks. Watermarks, they are essentially a transparency technique. So what they do is that when you have a content that is synthetically generated or AI generated, the watermark is a unique signature added to that content that signals that that content is the output of an AI model. Usually, the process of watermarking a certain digital content requires that 1. You teach an AI model that that model must add watermarks to its outputs, and 2. You must have algorithms out there that are capable of reading the watermark and interpret that as a content that was AI generated. Yet, as pointed out by the European Parliament itself, there are plenty of shortcomings when it comes to watermarks. So, there are doubts about how robust the solution is, the accuracy of watermarkers, and as well how the technical implementation could be carried out. When it comes to this last point about technical implementation, for example, we have a scenario right now where we have many private companies developing their own AI watermarks, and this might create some standardization issues. In case of watermarkers then, what regulation could help is by creating certain standards and common ways to operationalize them. Here, I must be fair and say that governments are already aware of it, and just last week, for example, the US and EU, they held some technical dialogues in which one of the main aims of those dialogues was to try and find standards for watermarking and content authentication in general. Lastly, the third type of technical remedy against deepfakes that I want to analyze here is the technical standards, and most importantly, the C2PA standard. The C2PA standard contains technical specifications to identify the provenance of digital content. The idea is that each piece of digital content out there will contain a hash in itself. This hash, on the other hand, will have the information on all the changes that that digital content has been submitted to, allowing us then to trace the origins of that content. The C2PA standard was created by a consortium of companies from both the tech and media industries, and it is definitely a very promising tool. But the success of it is largely dependent on how well the wide public will accept, adopt, and also understand this technology. So what we could consider here is potential regulations or general government actions and campaigns that raise awareness about what deepfakes are and educate population towards them. To sum up, what I wanted to show in this section is that technological remedies against deepfakes are probably the best way we have to actually fight deepfakes. The only problem being is that their overall efficacy might be dependent or could use a little bit of help from regulations. Our analysis of different regulatory frameworks will start by regulations that are already existing, such as, for example, the GDPR or the DSA. We will start with the GDPR because a lot is asked nowadays of how effective privacy regulations are on protecting us against deepfakes. And in that sense, the GDPR is one of the most influential privacy regulations out there. The first question worth asking here is whether the GDPR is actually applicable to deepfakes. And the short answer is yes. Deepfakes, all the time, will involve some type of processing of personal data. So the fact that the outcome of that processing, so the deepfake itself, the fact that the deepfake is faked and it has incorrect data, it doesn't mean that the GDPR is not applicable to them. In a research conducted in 2022 by the researchers Van der Sloot and Wagensveld, they deep dived into the GDPR and pointed out to some issues in the use of the GDPR as a legal tool against deepfakes. One of the bottlenecks, the shortcomings that they point out to, for example, is the processing of sensitive information. If you read the GDPR very carefully, you're going to see that deepfakes based on sensitive data would be almost always prohibited, unless there is explicit consent. But I think we can all agree that more often than not, deepfakes will not be consented to. The exercise that would be needed here to deliberate whether that deepfake has or not the right legal basis to process data would be to ask if the social interest over that deepfake being shared, for example in the case of satirical content that could foster the public debate, if that social interest prevails over the data subject's privacy rights. This is a very complicated and oftentimes arbitrary assessment to make. Another shortcoming that the authors found in the GDPR is some tensions with the idea of purpose limitation. So, purpose limitation is a principle under GDPR. What it says is that personal data should only be collected for specified, explicit, and legitimate purposes, and cannot be further processed in a manner that is incompatible with those purposes. The problem here is that many deepfakes are based on data that is scraped from the internet in an undiscriminate manner. So most of the data probably was not collected for the purposes of being processed into a deepfake. Lastly, another tension that we could highlight is that the GDPR also lays out an obligation that data processed must be corrected. So the GDPR requires that the processing of data must be correct and complete. And if data is incorrect, individuals can demand for that data to be corrected. The issue here is quite intuitive because deepfakes are by definition fake. So according to the authors, it seems plausible that data subjects always have the right to correct the material, to correct the deepfake. The authors, they went on to find many other possible legal bottlenecks in the GDPR. But what is important for us here in our conclusion is that in some cases, invoking the GDPR might be too restrictive. Many of the deepfakes that we see nowadays will violate the GDPR in one way or the other. The problem with such a restrictive framework is that it could also be too tight in addressing synthetic content that are not deepfakes or synthetic content that are not malicious. This altogether could very easily clash with other rights that we have, such as the right to freedom of expression. So, all in all, the conclusion here is that the GDPR was not conceived with the particularities of the so-called synthetic society in mind. And therefore, even though the GDPR as a legal instrument is applicable to the case of deepfakes, it might not be the most appropriate legal remedy. Same conclusions could be reached, for example, if we analyze the DSA. The DSA is another piece of legislation by the European Union, and we have a video in our channel about it, so if you're curious, go have a look at it. But what is important to have in mind right now when it comes to the DSA and deepfakes is that even though this is a much newer legislation when compared with the GDPR, for example, it still has many shortcomings when it comes to properly addressing deepfakes. So, for starters, the DSA, it doesn't define what deepfakes is, but it does require two main points. So, it requires that content that is generated or manipulated should have prominent markings, so that appeals to that notion again of watermarks, a type of transparency requirement. And the DSA also seeks to offer some type of protection against deepfakes through its provisions regarding content moderation. So the DSA has created a mechanism, call it notice and action, where users of digital platforms, they can flag to the owners of those platforms if they find any type of content that they believe to be illegal. And the platforms, on the other hand, have the duty to investigate that and take the content down if it comes to that. But these two provisions altogether are arguably not enough to protect us against deepfakes, because they only act once a deepfake is already out there and the damage is already done. And other than that, there are at least two other important bottlenecks when it comes to the DSA that is worth having a look. And both of them relate to the scope of applicability of the legislation. So, the DSA, it covers only the so-called intermediary services, such as internet providers or other types of platforms. This means that tools that can easily generate deepfakes, such as ChatGPT, for example, are not covered by the legislation. A deepfake that is created through ChatGPT would only be covered if this deepfake, once created, is then distributed in the venues that are actually regulated by the DSA, such as social media. Another problem is that even though the DSA regulates or has oversight over certain platforms, it explicitly exempts from its jurisdiction private messaging services. So services such as WhatsApp, which is this huge venue for deepfake distribution, are also not covered by the DSA. So, to wrap up the section about existing regulations, I think the analysis of both the GDPR and the DSA, they reinforce that regulations, when it comes to tech regulations more specifically, can get outdated incredibly quickly. And therefore, they need some perfection, they need some amendments in order to be able to accommodate the new threats posed by deepfakes. Let's have a look now in some new regulations. Regulations that were recently approved or regulations that are being negotiated as we speak. Regulations that in general were conceived with this AI reality in mind. Let's start by the European Union, more specifically the EU AI Act, which was published in July 2024 and will soon be enforced. So, what does the EU AI Act says about deepfakes? In general, the Act does not prohibit deepfakes in any way, but rather places transparency requirements on them. So if we have a look in Article 50, for example, paragraph 2 says that providers of AI systems, including general-purpose AI systems that can generate synthetic audio, image, video, or text content, shall ensure that those outputs of the AI systems are marked in a machine-readable format and detectable as artificially generated or manipulated. So essentially, what this paragraph is saying is that providers of technologies that can generate deepfakes should make sure that any synthetic content created by those technologies should have a watermark. And on the other hand, paragraph 4 of Article 50 also places some obligations on those deploying deepfakes or creating deepfakes. Paragraph 4 says that deployers of an AI system that generates or manipulates image, audio, or video content constituting a deepfake shall disclose that that content has been artificially generated or manipulated. When reading these provisions, the first thing that comes to mind is whether transparency obligations are a sufficient remedy against deepfakes, given the significant threats that deepfakes pose to both individuals and social interests. So, for example, transparency requirements will not minimize certain harms. In the case of a pornographic deepfake content, arguably the victim of this deepfake will be equally harmed regardless of whether the content is labeled as AI generated or not. Additionally, besides this the shortcoming when it comes to the transparency requirements, the Act does not offer any scenario for compensation or any type of remedy that the victim can use in order to protect himself or herself. And also on top of that, the Act does not prescribe measures to handle non-compliance with those transparency obligations. So in general, the Act lacks some enforcement measures. It is difficult to imagine, for example, that fraudsters, who are malicious actors by nature, will willingly signal that any synthetic content they generate is actually a synthetic content. Lastly, one thing that could be criticized about the Act is the fact that there are some exemptions to those provisions that I just read. So exemptions to the requirements for providers and deployers of AI systems that can generate deepfakes. So these exemptions apply, for example, when the deepfaked content forms part of an evidently artistic, creative type of work. And the issue here is that there is no further definition of what a purely artistical work would be. So this generates some questions and some uncertainties. All in all, to wrap up the EU AI Act and deepfakes, I think the EU AI Act is a groundbreaking legislation in trying to regulate AI in the way it does. But its actual efficiency, especially when we are talking about deepfakes now, will be largely dependent on secondary legislation and legal interpretations of the Act that hopefully will give some clarification in provisions that are a bit ambiguous and facilitate the implementation of the Act. Now, we'll cross the Atlantic and look into how the US is handling the issues of deepfakes. We have already explored about how US regulates AI. This was in my second video here in the channel that you should also have a look if you haven't yet. But the way the US handles deepfakes is to some extent similar to how it regulates AI. In general, we have already enacted deepfake-specific regulations in the states in the US, so Texas, California, Illinois. They all already have enacted regulation about deepfakes. But then on a federal level, we have many initiatives, but no actual regulation yet. None of those many initiatives, many legislative bills have been approved. Yet, despite that, there are very interesting pieces of legislation that try to regulate deepfakes from many different angles. So that is why it's worth having a look at them. So, for example, already in 2023, there is a so-called No Fakes Act that first showed up as a discussion draft bill. But now, in 2024, senators from both parties in the US are pushing for this act to be introduced as an actual bill. What makes the No Fakes Act special is that it tries to regulate deepfake in a very different way. It doesn't talk about transparency requirements or any of the things that the DSA and the EU AI Act relies on. Actually, it tries to build a consent regime around it, similar to what some privacy regulations do. So first, it established the concept of digital replica, which is a concept broad enough to include deepfakes. And also it established the digital replication right, which in other words is the right of the individual to authorize the use of his image, voice, and visual likeness in a digital replica. So what the bill does is that it allows one individual to hold other individuals or companies liable if those other individuals and company produce an unauthorized digital replica of him or she. It also allows to hold platforms liable for hosting an unauthorized digital replica. So the bill, the future bill, actually doesn't regulate deepfakes directly, but build this consent regime that is quite interesting to look at. We also have in the US Biden's executive order, so not a legislative bill, an administrative act that was published by the Biden administration in October 2023. And the executive order is huge, but in some parts of it, it talks about deepfake. And most importantly, it places an obligation in the Secretary of Commerce to develop standards to label AI-generated content. This standard should be published soon if we follow the executive order's timeline, and it will include information on many different aspects of deepfakes, including the details, tools, techniques that are necessary to authenticate content and track its provenance, label synthetic content, detect synthetic content, so on and so forth. So it's definitely a standard that we should have our eyes on from now onwards, see what happens out of it. In 2024 alone, the legislative production in the US Congress has also been immense, probably because this is an election year in the US. So only in January 2024, we have already at least 2 other bills related to artificial intelligence and more specifically deepfake. So we have the No AI Fraud Act and also the Defiance Act. So both of them trying to give some legal remedies for people that are victims of deepfakes. And it is worth noting, precisely because it is an election year in the US, that there's also been a special combo in the Congress of bills regarding deepfake and elections. So we have the AI Transparency in Elections Act. We have the Preparing Election Administrators for Act. This one is very interesting. So it is a bill to require a commission to develop voluntary guidelines for the administration of elections to address the use and risks of AI and deepfakes, so more or less creating awareness campaigns. And in this combo of bills related to deepfake and elections, we also have the Protect Elections from Deceptive AI Act. This is a bill to prohibit the distribution of materially deceptive AI-generated audio or other visual media relating to candidates for the federal offices. All in all, there is a myriad of different deepfake-related bills in the US Congress. It is not clear to which extent those bills are complementary or in which scenarios they clash with each other, and it is much less clear which of these bills will be actually approved and further enacted. Thinking about what the policymakers will probably keep an eye on from now onwards, is to consider whether these bills can produce a cohesive regulatory framework, and most importantly, trying to understand how these bills can work together, can create a cohesive regulatory framework with the already enacted state deepfake bills. So there is this map elaborated by Multistate AI, where it shows all the bills already approved or being currently negotiated when it comes to deepfakes on a state level. It is important to notice that most of these bills are very narrowly focused, so they focus on either deepfakes generated in the context of elections or pornographic deepfakes. But it is still quite impressive how quickly legislators in all the states came up with answers to these questions very quickly. We are now going to have a quick look into what China is doing when it comes to deepfake regulations. This will be a very brief overview, mostly because we have already covered the Chinese approach towards AI regulation in another video here in our channel. And most of the Chinese regulations on AI touch to some extent on the question of deepfakes. So China has this very hands-on approach when it comes to AI regulation, so it is not a surprise that the country was the first country ever to have a regulation targeting specifically deepfakes. The Chinese approach towards deepfake regulation, including two different regulatory pieces. First, we have the deep synthesis regulation, and later the generative AI regulation. I think a distinctive feature of these two regulatory pieces together is that, in conjunction, they offer both some ex-ante and ex-post protection against deepfakes. So it set rules, the regulations, they set rules for before the creation of deepfakes, but also rules for its sharing. So it requires that providers take steps to mitigate the misuse of their technologies capable of producing deepfakes. And once deepfakes are produced, they're also subjected to some controls, such as, for example, the indication that that content is artificially generated. Now we'll end in Australia. Australia has recently introduced a draft bill to combat the sharing of sexually explicit deepfakes. The bill will essentially amend Australia's criminal code to introduce a new type of criminal offence aimed at banning the use of carriage services to transmit sexual materials of another person, either without the consent of the victim or if the transmission was reckless. What I think is interesting to notice here is that, first of all, it tries to have as its scope of applicability all carriage services, a term that is very broadly defined in the regulation, to be able to encompass as many venues of deepfake distribution as possible. I think it is interesting to say it because in the DSA, which was conceived a couple of years ago, like we said before, it doesn't cover venue of messaging services such as WhatsApp or technologies such as ChatGPT. So the Australia regulation, which is much newer, just being proposed, it tries to encompass as many venues as possible. And another interesting aspect of it is that it doesn't use the term deepfakes explicitly. It talks about sexually generated content, and I think this is also another way that the regulation seeks to be future-proof. Because many years ago, we could not foresee the technology deepfake, and it could as well be the case that some years from now, we're going to have another type of synthetically generated content, much more dangerous than deepfakes. So by using this neutral language, instead of referring only to deepfakes, and by trying to have this very broad scope of applicability, the Australian case is a very interesting way of regulations that try to be flexible and future-proof. Now we're going to move to the UK, which is the last country we will analyze today. Differently from many others, the UK does not have one legislation specifically targeting deepfakes. Instead, in 2023, what it did was to include the issue of deepfakes in the negotiation of its now Online Safety Act. So what the Act does now is that it has dispositions that criminalize, make it illegal, the share of explicit images or videos that have been digitally manipulated. So the law changed two main things. First, victims no longer have the burden to prove the intent to distress for sharing the non-consensual intimate images. And now, the sharing of non-consensual intimate images also becomes a serious offense. The problem here, as many experts have pointed out, is that the law might just be not enough. The Online Safety Act, it focuses on discouraging malicious actors from behaving maliciously, from producing deepfakes, but does not offer broader prevention tools or protection to the victims. A similar criticism is applicable to the EU AI Act. As we saw, the EU AI Act also focuses on transparency measures and therefore only acts when the damage is already done. And because of that, in the last section of this video, and already moving towards our conclusion, we are going to analyze the fact that if none of these regulations are perfect, what a perfect, ideal deepfake regulation should look like. To answer to the question of what an ideal deepfake regulation should look like, I like to portray deepfakes as a phenomenon that has its own life cycle with different stages. By doing so, I believe it is clearer to understand at which stages policymakers should step in and which measures they should take. So, the general deepfake life cycle goes something like this. First, the technologies capable of creating deepfakes are released into the world. Here, something to consider is whether we can think if there is anything that the providers of these technologies should do. What could be preventive measures they could take? In an ideal world, for example, appropriate safeguards, they would also include to ensure safety by design, meaning that actors should not even be allowed, or it should not even be possible to create exploitative, malicious deepfakes. The second stage of the life cycle is when the malicious exploitative deepfake is created. Here, I took the care to specify, to use the word malicious or exploitative, because this is the main type of deepfake that we want to regulate, right? We don't want a total ban of it. But this is actually the question the policymakers are asking themselves.
La mia voce e la mia immagine da catturare in un computer.
And with AI tools, I can say
anything to anybody.
So, should certain types of malicious deepfakes or deepfakes at all be banned? Or should we limit to some extent the production of deepfakes to be restricted to some specific actors and industries, limiting the overall population's access to it? Debatable.
It was sent to me by a friend who believed it.
Don't be afraid to invest and start enjoying the fruits of your labour.
It's not hard to find a fake Dick Smith online spruiking an investment scam.
And lastly, the third stage of the life cycle is when the malicious deepfake is distributed. So it first is created and then it is distributed. This step is the one regulators are questioning the most, and the main question they're posing here is whether existing regulations can be applicable. There are already many regulatory frameworks on defamation, content moderation, privacy, consumer protection, so on and so forth, and now we're all wondering how effective those are. Like we said previously, that might not be the case for all of them. So what can we take from all of this? What we can take from this is that intervening in the first two stages might be too complex for now. So intervening on the stages of when the deepfake technology is created or when the deepfake itself is created, it's complex and it will take time, mostly because the technology is still evolving. So we need to wait a little bit, understand the phenomenon before we can step in and regulate it. And this leaves us with stage 3, therefore, where the debates are now concentrated. Potentially because this is maybe the easiest to regulate, right? Because maybe this is the one with all the already existing regulations. Like we saw before, none of them are perfect, but this in the foreseeable future, in the short term, these will be the legislations that we will seek to as legal remedies against deepfakes. However, this conclusion should not discourage in any way policymakers to get creative and try to better target deepfakes. And another reason for that, I would say, is that many of the existing enacted laws are only aimed at offering protection against deepfakes in scenarios of elections or deepfakes of pornographic content. This is what we saw, for example, in the case of legislations in the US states, or the new bill in Australia, or the case of the amendment in the Online Safety Act in the UK. All of them tend to target only deepfake that are created for pornographic purposes, for example. And whilst this is one of the most dangerous cases of deepfakes, this is not the only one. In a research about how generative AI has been misused, Google DeepMind's researchers, they discovered that when using generative AI tools for the misuse of impersonation, so creating a digital content that takes over someone's identity, the main goal of impersonation is actually to perpetrate scams and fraud. Another interesting find is that when analyzing all the misuses of generative AI, the second most popular goal of these misuses is also to scam and fraud, corresponding to roughly 20% of the analyzed cases of misuse. So, in other words, deepfakes are also being used by fraudsters to open illegal bank accounts, conduct illegal money transfers, blackmail, and many other types of threats and distress. So ideally, deepfake regulations needs to start paying attention to these cases as well. So, as a conclusion to all of the things we discussed, I want to say that none of the existing regulations are perfect, but we should take them from now. In the short term, they might be the only remedy, our only shot against deepfakes. In parallel, however, they should not discourage policymakers from investing and getting creative and coming up with new regulations targeting deepfakes specifically, and also covering all the potential cases of it, including scams, frauds, so on and so forth. That was it for today. I look forward to hear your comments. If you like our videos, please leave your like, follow our channel, and see you in the next one. Bye bye.